Hello everyone. So this is a video on a very pertinent judgment, a judgment which came out say a few days back only, and it deals with a very important question that relates to legalities of arrest. Okay, so this judgment thoroughly deals with the issue of what the laws on arrest are and what is the jurisprudential explanation of those laws by the various courts so far. And then at the end, it categorically lays down certain binding and exclusive principles for the for all peoples to follow throughout the country. So this is a case that arose out of bail application, and this judgment was delivered by virtue of clubbing two, three criminal appeals and special petition. So the main issue in all of these cases, appeals and these SLP, was that the appellants on all of these cases, they are claiming that the right, fundamental right under Article 22 of the Constitution, along with the procedural safeguards that an accused has by virtue of Section 50 of CRPC, which is now 47 of BNSS, have been violated. And they say that because of this violation, the arrest made under by the police against them is illegal arrest. So the challenge against the legality of the arrest first went to the Supreme Court, wherein the Supreme Court held that yes, there has been a procedural lapse, that is, the accused or and the arrested person was not informed of the grounds of the arrest. The court says that not in fact, despite the fact that they were not informed of the grounds of their arrest, the court held that. Remember, we are talking about the High Court, where these cases went first before coming to the Supreme Court, held that okay, maybe there were procedural lapses, but that will not vitiate the validity of the arrest itself. The court says that the appellants were consciously aware of the gravity of their offense. That means the arrested people already knew what they have done, and they were already aware for of the reasons for which they were being arrested. Secondly, the court held that there were enough and substantial evidences against arrested people in these cases. And then the also another fact was that the arrested person uh, tried to evade the arrest, and all of these circumstances the court says is a good justification for the investigating authorities to bypass the procedural safeguards that are provided in Constitution, CRPC, and all of that. So here and on paragraph 7, the court is laying down the two key questions of the law that the court is going to specifically answer by virtue of this judgment. The first is that whether in each and every case of an offense where arrest is being made, be it a case under IPC, BNS, or any other law such as Money Laundering Act or the Unlawful Activities Prevention Act, the court's first question is whether in each and every case, irrespective of the law in question, would it be necessary to furnish the grounds of arrest to the accused either before the arrest or forthwith after arrest. Forth means right after the arrest. So this is the first question, that when should the grounds be furnished, and the second key question here is whether even in exceptional cases where no account of certain on account of certain exigencies, it would not be possible to furnish the grounds to the arrest either to the arrested person either before or immediately after the arrest. The arrest will be vitiated on the ground of non-compliance with the law. So the second question before the court is that whether the necessity of providing the grounds of arrest are to be complied with immediately after the arrest or before the arrest in exceptional cases. The exceptional cases that are being referred here to are cases where a person is immediately found, you know, of is say for example is captured red-handed doing something, maybe taking a bribe, or like was the case in this case when a person is found hitting another person, killing another person, and is now running away from the scene of the crime. So the second question that the court has framed here relates to those exceptional circumstances, and the court is saying that whether the requirement has to be fulfilled before or immediately after the arrest in these cases also. Later, we will see the court is using a very particular phrase in order to describe these exceptional cases. So, in this case, there were three people who were arguing before the court. One was the counsel for the arrested person. Second was the counsel for the from the prosecution side, and thirdly, the court had invited an amicus curiae also for its opinion. So, first are the contentions mentioned by the senior counsel for the appellants, that is the arrested people. They are referring to three celebrated judgments. First is the Pankaj Bansal's judgment, then they are referring to the Vihan Kumar's judgment and also the Pradeep Purkaesta's judgment. All of these judgments have been dealt with by the court also thereafter. And then the counsel for the arrested people is contending that providing the arrested person with the grounds and the reasons for his arrest is a basic requirement which flows not just from a procedural law but also from the constitution, and therefore cannot be sidelined or bypassed by investigating authorities. Whereas the counsel for the state, that is the respondents, they are saying that the uh, mode of communication of grounds and the time of communication of ground are not specifically mentioned in either BNSS or in the Constitution. Now, here will come a question of interpretation that also has been dealt with by the Supreme Court. That how are we to read the mode and the time of arrest in these provisions when it is not specifically mentioned? So, now is the court at the liberty to read it anyhow, or something from the context in which these provisions are made has to be drawn? These are another key questions that the court answered. So the judgment, after dealing with the contentions from both the sides, is talking about the different provisions under which the right to be provided with the grounds of arrest is being claimed. The court is first of all referring to Article 21, which the court says is the genesis of this entire issue. The court here is pointing out that this Article 21, which says that nobody shall be deprived of right of his deprived of his life or personal liberty. The court here is pointing out that it is the term personal liberty which is of key concern here, and it includes procedural safeguards, because these procedural safeguards are the one that are going to protect a person from the abuse of power by the state agencies. And these procedural safeguards are to be read in Article 21 only, because it uses the term personal liberty. How is the personal liberty going to be safeguarded? Only if there are procedural safeguards that are strict in its application and are strictly complied with. Thereafter, the courts are saying that along with Article 21, Article 22, which also is part of the Constitution, is further strengthening or is providing impetus to the same protection of people's personal liberty. Later, the court says that it is from these two articles, 21 and 22, it is from these two articles only that the provisions in the CRPC, that is Section 50 and now Section 45 of BNS, are coming from. These provisions of the procedural law are flowing from the Constitution itself. Thereafter, the court is referring to one another provision of the procedural law, which says that the grounds of arrest are not only to be provided to the arrested person, but the protection of this provision is extended, and it also demands that the grounds of arrest shall be provided to one of the family members, relatives, or a nominated person of the arrested person. So the court here is saying that it has an extended scope. This procedural safeguard is an extended scope and is finds place in the new law also, that is Section 48 of the BNSF. Further, the court is discussing different judgments that have been delivered time and again by the Supreme Court on the same issue. Firstly, the court is discussing the Pankaj Bansal's case, which was referred to by the counsel for the arrested people also. This case related to arrest under Section 19(1) of the Prevention of Money Laundering Act. So here lies a difference that this case relates to a more stringent or a specific law, whereas the present judgment relates to deals with this issue in general. That is not just the specific laws, but any offense, be of lesser gravity also under any law, be it BNS, IPC, which is generic in nature. So the court, by virtue of referring to Pankaj Bansal, says that in this judgment, the court had held that the manner in which the grounds are to be communicated should be such that it is a effective communication, and therefore, though the court says it is uh, that it is imperative that the authority shall furnish the grounds in writing. Now, why is this requirement there? Because if the grounds are not required to be communicated in writing, there and it can orally be and the court and the authorities are allowed to just orally communicate these grounds to the arrested person, then this is going to be a very difficult situation, because mere communication in the absence of written documents would render the compliance susceptible, meaning suspicious. It will be very hard to prove that these grounds were not communicated. And if communicated, it will be difficult for the authorities to prove that they were actually communicated. Plus, any oral communication there are chances of it being inefficient, because a person who's been arrested and is being taken away by the police will not be in a state of mind that he will be able to register the nitty-gritties of what is being told to you. He would most likely be in a state of panic. Thereafter, the court is referring to another judgment of Prabhi Purkayastha. This judgment also relates to a special law, that is Unlawful Activities Prevention Law. But the key point laid down here was the same. The courts held that communication in writing of the grounds of arrest is needed, is not just a fundamental procedural requirement. This is a fundamental and a statutory right of a person to be arrested, and also this communication shall be made at the earliest without any exception. The court says that it is not a mere procedural formality, but an important, vital safeguard which with the ultimate objective to enable the arrested person with an effective legal consent. So we all know what happens after arrest. The person, if needs to be kept more than 24 hours, he is produced before a magistrate. The magistrate therein, when the arrested person is produced, applies his judicial mind and decides whether the custody needs to be extended, and also whether the custody needs to be a police custody or a judicial custody. So when the judge is applying its mind, the the arrested person's interest is at stake. His liberty is at stake. Liberty which is not to be dealt with lightly. It is a constitutional protection that that is afforded to a person when a question of personal liberty arises. So, does this arrested person have a role to play when the magistrate is deciding this issue? Yes, he certainly does. This is where, if he is informed of the ground, and if he, by virtue of that information, able to hire a legal assistant who's able to effectively put forth his case, will all of this will save the arrested person from further custody. And therefore, this is a very important right, that the person who's arrested is told of what is it that he's being taken in for. The third judgment that court referred to is the Vihan Kumar's judgment. This also is a very recent judgment, wherein the court highlighted and underscored that yes, statutorily no timeline, no mode of communication for arrest has been mentioned, but the court reiterated that the most effective, most ideal form of communication of the grounds of arrest are going to be in writing. Court says that those statutes do not demand that, but the spirit of the law is such that it will not serve the purpose unless the communication is an effective communication, and which demands that it should be done in writing. Important here is for us to note that the court also laid down that it will not be practical to communicate the grounds of arrest in every case, but the court is cautioning that if given in writing, that will only save the authorities from the controversy arising out of this non compliance. So they are saying that there are going to be particular practical hurdles, but that will also safeguard and the integrity of the whole arrest. The court, by virtue of reference, is also discussing here about the impact of an arrest. The court is here being empathetic of the situation, and also of the disturbance that an arrest creates in a person's life. Because, mind you, we're talking about a situation where a person is only accused of having committed something, nothing has been proved against him. That too, it is a very, very initial stage of investigation. Whereas, so on, it is not going to be a very substantial piece of information that the police has in many cases, and yet the arrest can really turn the world upside down for the person who's arrested and the people associated with the person. We know it is going to impact his social well-being, his psychological well-being, and it is seen as a taboo that once a person is arrested, it really leads to a situation, a social situation, where everybody raises their eyebrows and questions that, oh, something, the person must have done something. So it is a big social taboo getting arrested. So here in these paragraphs, the court is talking about why this protection is there. It is the protection, as we discussed earlier, is there in order because it is part of one's right to life. The court is saying that the other reasons for this specific procedural safeguard and protection is that it will enable the arrested person to understand the very basis of his arrest, and therefore accordingly he will be in a position to engage a legal counsel who would then help him in challenging the arrest or in matters of remand or seek bail or avail any other remedy which is permitted to this person under the law. Further, the court is saying that this arrested person, the earliest he is able to access the legal aid, the better it is for him. The more effective defense he will be able to put before the magistrate. And this early access to legal counsel becomes very, very important to protect a person's liberty. So, right after 24 hours, when the person is produced before the magistrate, that is where he gets the first opportunity to speak for himself, to defend himself. And that is will be effectively done only and only if he has a counsel and if the counsel and he himself are aware of what they are fighting against. Further, by virtue of deliberation, the court is saying that the duty cast upon an authorities, investigating authorities, of providing the grounds for arrest is a mandatory unexceptional duty. Unexceptional duty is a key term, and it tells us that there are going to be no exceptions in this area. So the authorities cannot claim that because it is a general law, not is a very specific stringent law, not a serious matter, then we can go about with the investigating procedure in a lenient manner. The court says that this procedure safeguard, specifically this one, cannot be subjected to any exception. And likewise is the case with Article 22(1), which says, which also again is subject to no exception. The court says that 22 is not statute specific. It applies to all statutes equally, and no statute can be uh, taken as an exception to Article 22. Likewise, Article 21 is applicable to all offences, including the specific general offences against under IPC. So, apart from the mode of communication, which we discussed has to be in writing, the court is then emphasizing on another aspect of it and is saying that when the thing is being put down in writing, it should be done in a language which is easily understood and read by the arrested person if he is a literate. Thereafter, the Supreme Court is saying that this sort of communication in writing in the language that is easily read and understood is not going to just help the arrested person. This also is going to be beneficial to the legislative agencies because then they will be in a stronger position to prove that they had complied with the requirements of the law as and when there is a challenge against the procedure is made. So this is going to be beneficial approach, not just for the arrested person, but also the arresting person. And the court says that is this appears to be the true intent of the constitutional mandate. The court saying that though clearly it's not been laid out that the communication shall be in writing, but if we read these two provisions and the other provisions of the procedural law together, it will be very, very clear that this is what was actually intended by the legislators or by the constitution makers. So this is not something which the court is imposing from their own end. This is what is the hidden or the latent intent of the lawmakers themselves, which is a key principle of interpretation law as well, that the judges have to abide by the intentions of the legislation. But that intention at times is hidden, is not patent, but is latent. Court thereafter turned to another key aspect in this case, was with respect to the time of arrest. So we dealt with two questions: the mode of arrest, the language in which the communication is to be made, the mode in which the communication to be made, and the third element is the time when the communication is to be. The Article 22 says that the communication shall be made as soon as it may be. So the indication is that it should be at the earliest instance. But there may be situations where it's not possible to communicate the arrest at the time, communicate the grounds of arrest at the time of the arrest. So the court is saying that the question of as soon as possible will be determined situationally. So if it is possible, say for example, it is a case of fraud where the authorities are already equipped with documents and other reasons for which they are arresting a person, they can beforehand communicate the grounds for arrest. At the time of arrest, can communicate the grounds of arrest in writing. So wherever it is possible, it should be done at the time or before the arrest. Whereas in other which involve a tangible or an imminent risk of suspect absconding or committing another offense. So, for example, if there is a police officer who's not who's who witnesses a murder being committed right in front of him, then it will not be possible for the officer to arrange for a written copy of the grounds. This is not what is intended by the lawmakers. They say that in these cases it shall be done post arrest, whereas like I discussed earlier, in instances that involve primarily document evidences or records, or which is a case of economic offenses, then the grounds can be effectively given in writing even at the time of the arrest simultaneously. So the court is saying that the police who are already in document possession of documentary evidences can provide the documents and the grounds of arrest at the time of the arrest, but in other cases. So here they are using this term flagrante delicto. Flagrante delicto means the cases where the offense, you have offender or the accused person is being caught red-handed. What do you do in those cases? In those cases, the authorities, of course, do not have time to get in writing the grounds of arrest. But yet, even in those cases where the court is calling as flagrante delicto, the Supreme Court has categorically laid down that the grounds of arrest shall be communicated in each and every case without failure 2 hours before the accused is to be produced before the magistrate. Because, like we discussed earlier, the whole issue is not just about protection; it's also is about a effective defense being made out before the magistrate. And the court says that any shorter interval, that is less than 2 hours, may render the preparation of his defense illusionary, and thereby non-compliance of this 2 hour threshold will vitiate the arrest and will vitiate the protection that the law affords to an arrested person. Lastly, and most importantly, the court laid down in 4 points the summary of the judgment. These are four binding key points, and the judgment is a reportable judgment. A copy of the judgment was made to be circulated to all states for compliance. We'll see what are these four guidelines. The first one is that the constitutional mandate of communicating the grounds of arrest applies to all offences, including each and every offence of IPC. Thereafter, the court says the second requirement is that the communication shall be made in writing using the language which the arrested person understands. Thirdly, if the arresting person is not able to communicate the grounds of arrest soon after the arrest, it shall be done so orally at least, and the communication in writing shall be made at least 2 hours prior to the protection of this person before the magistrate. So if you can not do it in writing immediately, do it orally, and the writing part has to be complied with at least 2 hours prior to producing him before the magistrate. The fourth and last necessary condition laid down by the Supreme Court is that in all cases of non-compliance with the above three conditions would render the arrest illegal and therefore will quash the arrest of the person, will be the person will be at the liberty and be set free. This is the latest judgment on grounds of arrest. It summarizes the law on arrest, the jurisprudence on arrest that has been developed so far, refers to three key and recent judgments of Supreme Court in other instances. So at present, I would say that this is the current law and is binding and needs to be understood clearly and categorically by all.